We begin our deep dive into congressional power by establishing the foundational structure of American governance, federalism. Federalism is the constitutional division of authority between the national government in Washington, D.C., and the individual state governments. This delicate balance is constantly tested, and nowhere is that tension more apparent than in the scope of Congress's regulatory reach. The primary source granting Congress the power to regulate national economic activity is found in Article 1, Section 8, Clause 3 of the Constitution, the Commerce Clause. This clause grants Congress the power to regulate commerce with foreign nations, and among the several states, and with the Indian tribes. For the purposes of the uniform bar examination, understanding the Commerce Clause means understanding precisely where federal power begins and where state sovereignty remains protected. This chapter sets the stage by identifying this crucial constitutional text that serves as the gateway to nearly all federal economic legislation we will examine moving forward, focusing on the inherent limits placed upon that authority. The previous chapter introduced the Commerce Clause text. Now we must see how the Supreme Court first interpreted this sweeping grant of authority. The foundational case is Gibbons v. Ogden from 1824. This landmark decision, authored by Chief Justice John Marshall, immediately signaled a broad reading of congressional power. Marshall defined commerce not merely as the buying and selling of goods, but broadly as intercourse, which explicitly included navigation. Crucially, Marshall interpreted the phrase, "among the several states," to mean that Congress's power does not stop at the external boundary line of a state. Instead, the power extends to all commercial intercourse that concerns more states than one. This established that Congress could regulate activities occurring entirely within a state, provided those activities affected or were part of the stream of interstate commerce. This early interpretation set the stage for nearly 2 centuries of expansive federal regulation. The broad interpretation established in Gibbons v. Ogden held sway until the Great Depression ushered in the New Deal era, leading to a dramatic expansion of federal authority. The court began allowing Congress to regulate not just the instrumentalities of commerce, like railroads or shipping, but also local activities that substantially affected the national market. The absolute zenith of this expansive view is found in the 1942 case, Wickard v. Filburn. Roscoe Filburn, a farmer, grew wheat on his own property solely for personal consumption and feeding his livestock, activities entirely local and non-commercial. Yet, Congress regulated this production under the Agricultural Adjustment Act. The Supreme Court upheld this regulation using the aggregation principle. They reasoned that if every farmer did what Filburn did, the cumulative effect on the national wheat market would be substantial. Therefore, even purely local, non-commercial activity could be regulated if, in the aggregate, it impacted interstate commerce. This decision represented the high watermark of Commerce Clause power. While Wickard v. Filburn seemed to grant Congress nearly limitless authority, the court soon applied this expansive view to address social issues, specifically racial discrimination in public accommodations. This marked a significant application of the substantial effects test beyond purely economic production. Consider Heart of Atlanta Motel versus United States. The issue was whether Congress could prohibit racial discrimination in a hotel that served travelers crossing state lines. The court said yes, finding that discrimination substantially burdened interstate travel and commerce. Similarly, in Katzenbach versus McClung, the court upheld the Civil Rights Act as applied to a local restaurant that purchased supplies from out of state. The court reasoned that the cumulative effect of denying service to patrons substantially affected the flow of goods across state lines. These decisions cemented the post-New Deal understanding. If an intrastate activity, even one seemingly local like operating a hotel or restaurant, had a substantial effect on interstate commerce. Congress could regulate it. This framework suggested federal power was virtually unchecked. The expansive view of federal power established by the New Deal cases seemed almost absolute. However, that era of deference ended in 1995 with the landmark decision, United States versus Lopez. This case marked the first time in over 50 years that the Supreme Court struck down a federal statute based on the Commerce Clause. Chief Justice Rehnquist, writing for the majority, established a crucial framework for analyzing Commerce Clause legislation. Congress can regulate three things: the channels of interstate commerce, the instrumentalities of interstate commerce, and activities that substantially affect interstate commerce. Lopez focused on the third category. The court held that possessing a gun near a school zone, regulated by the Gun-Free School Zones Act, was not an economic activity. Furthermore, the connection to interstate commerce was too attenuated, too indirect, even under the substantial effects test. The court drew a bright line: purely non-economic activity, like possessing a firearm locally, falls outside Congress's reach. If Lopez drew a line against regulating non-economic activity, the court immediately reinforced that boundary 2 years later in United States versus Morrison. This case challenged the constitutionality of the civil remedy provision within the Violence Against Women Act, which allowed victims of gender-motivated violence to sue perpetrators in federal court. The government argued that violence against women substantially affects interstate commerce, invoking the aggregation principle used successfully in Wickard. However, the Supreme Court disagreed. Writing for the majority, Chief Justice Rehnquist explicitly stated that the regulated activity, gender-motivated violence, was not economic in nature. Unlike the wheat in Wickard, violence is not an activity that Congress can aggregate to find a substantial effect on commerce. The court refused to allow Congress to regulate purely non-economic activity simply because the consequences might indirectly ripple into the national economy. This decision firmly established that the aggregation principle only applies when the underlying activity being regulated is economic. Violence, like gun possession, remains outside the core of Commerce Clause authority. If Lopez and Morrison established a firm line against regulating non-economic activity, Gonzalez versus Reich, decided in 2005, immediately tested that boundary. The question here involved the Federal Controlled Substances Act banning the cultivation and use of marijuana, even when grown and consumed purely for medical purposes within California, where state law permitted it. The government argued that this activity, like the wheat in Wickard, was economic and subject to aggregation. The Supreme Court agreed, upholding the federal ban. The key distinction the court drew was crucial. While growing marijuana might seem purely local, the court classified the activity itself, the production, distribution, and consumption of a commodity, as inherently economic. Therefore, the aggregation principle applied, just as it did for wheat. The court reasoned that allowing a massive, unregulated local market to flourish would substantially affect the national market for marijuana. Thus, Reich carved out an exception. Even purely local activity can be regulated if it is economic in nature, distinguishing it sharply from the non-economic activity found in Lopez and Morrison. We have spent significant time analyzing the scope of Congress's power under the Commerce Clause, what activities it can reach. Now, we must shift our focus to the structural limits imposed by the 10th Amendment, which restricts the means Congress may employ, even when regulating activities within its enumerated power. This leads us directly to the anti-commandeering doctrine. This doctrine is a fundamental check on federal authority, rooted in the principle that the federal government cannot simply conscript state resources or personnel to execute federal policy. The Supreme Court established this clearly in two landmark cases. First, in New York v. United States, the court struck down a federal law requiring state governments to take title to radioactive waste. More definitively, in Prince v. United States, the court invalidated provisions of the Brady Handgun Violence Prevention Act that required state and local chief law enforcement officers to conduct background checks pending federal approval. The core holding is absolute. Congress cannot compel state legislative bodies to enact laws, nor can it compel state executive officials to enforce federal statutes. This preserves the distinct sovereignty of the states. Now that we have examined the structural limits imposed by the anti-commandeering doctrine, let us synthesize everything into a practical framework for analyzing any Commerce Clause challenge on the bar exam. Your analysis must proceed in two distinct steps. First, determine the scope of the power being asserted. Ask, is the regulated activity economic in nature? If the answer is yes, Congress can likely rely on the aggregation principle, as seen in Rake. If the activity is non-economic, such as possessing a gun near a school or gender-based violence, the regulation will likely fail under Lopez or Morrison. Second, regardless of whether the activity is economic, you must check the means Congress employed. Does the statute attempt to commandeer state legislative or executive resources? If yes, the law is unconstitutional under the anti-commandeering doctrine, irrespective of the economic nature of the underlying activity. This dual structure, scope and means, reflects the enduring tension between addressing national needs through robust federal regulation and preserving the structural sovereignty of the states. This balance defines modern federalism.